5 seconds to go. Start. 30 years of pensionable service, as the case may be, should such extension be deemed desirable in the interest of the bank. However, the second proviso clarifies that an officer who has attained the age of 60 years shall not be granted any further extension in service. From a comparative analysis of Order 19.1 of the Service Order with Rule 19.1 of the Service Rules, what is discernible is that the only change introduced by the latter is in one of the conditions of superannuation, that is the age. From 58 years, it has now become 60 years. Rest of the provision has remained unaltered, including the contingencies of superannuation. Whether it is 58 or 60 years, it is only one of the contingencies of superannuation, not the sole. Before attaining the age of 58 years or 60 years, as the case may be, an officer shall superannuate from service if he has completed 30 years of service or 30 years of pensionable service. However, the second proviso has made a clarification that an officer who has attained the age of 60 years shall not be granted any further extension in service. This means that an officer can be superannuated before attaining the age of 60 years if any one of the other two contingencies are fulfilled. He may also be granted extension of service thereafter, but such extension of service cannot be beyond the age of 60 years. Rule 19.2, on the other hand, starts with a non obstante clause. It says that notwithstanding anything to the contrary in the service rules, no officer who has ceased to be in the bank's service by the operation of or by virtue of any provision shall be deemed to have retired from the service of SBI for the purpose of the Imperial Bank of India Employees Pension and Guarantee Fund rules or the State Bank of India Employees Pension Fund rules unless such cessation of service has been sanctioned as retirement for the purpose of either of the said pension fund rules as may be applicable to him. Thus, what Rule 19.2 contemplates is sanctioning of cessation of service for the purpose of the aforesaid two rules only and for no other purpose. Sub Rule 3 of Rule 19 provides that in case disciplinary proceeding under the relevant rules of service has been initiated against an officer before he ceases to be in the service of SBI by operation of or by virtue of any of the said rules or the provisions of the service rules, the disciplinary proceeding may, at the discretion of the competent authority, be continued and concluded by the authority by which the proceeding was initiated in the manner provided in the said rules post cessation of service, as if the officer continues to be in service, but he shall be deemed to be in service only for the purpose of continuance and conclusion of such proceeding. Chapter 11 of the Service Rules deals with conduct, discipline, and appeal. Chapter 11 comprises of Rule 50 to Rule 70. Section 2 of Chapter 11 deals with discipline and appeal. Rule 67, which is part of Section 2, provides for various categories of minor and major penalties which may be imposed on an officer for an act of misconduct or for any other good and sufficient reason to be recorded in writing. The heading of Rule 68, which is also part of Chapter 11, is Decision to Initiate and Procedure for Disciplinary Action. Rule 68.1 says that the disciplinary authority, either by itself or on a direction of the superior authority, may institute disciplinary proceeding against an officer. The disciplinary authority or any authority higher than it may impose any of the penalties mentioned in Rule 67 on such an officer. As per Rule 68(2), no order imposing any of the major penalties shall be made except after an inquiry held in accordance with Rule 68(2). Clause 3rd of Sub Rule 2 of Rule 68 says that where it is proposed to hold an inquiry, the disciplinary authority shall frame definite and distinct charges on the basis of the allegations against the officer and the articles of charges together with the statement of allegations on which those are based, list of documents and witnesses relied on, copies of relied upon documents to the extent possible, and the statement of witnesses shall be communicated in writing to the officer, who shall be required to submit within such time as may be specified by the disciplinary authority a written statement of his defense. Thereafter, the procedure for conducting inquiry is laid down. Rule 69 provides for appeal and review. As per Sub Rule 1, an officer may appeal to the appellate authority against an order imposing upon him any of the penalties specified in Rule 67 or against an order of suspension. The procedural part of such an appeal is provided in Sub Rule 2. Rule 69(3) deals with review. Clause 1 thereof, which starts with a non obstante clause, says that notwithstanding anything contained in Section 2, the reviewing authority may call for the record of the case within 6 months of the date of the final order, and after receiving the case, pass such orders thereon as it may deem fit. In Union of India versus K.V. Janaki Raman, this court was examining the impact of sealed cover procedure on an employee due for promotion, increment, etc. In that case, the employees were eligible for promotion, but because of pending disciplinary proceeding, were subjected to sealed cover procedure. It was in that context that this court considered, amongst others, the question as to what is the date from which it can be said that a disciplinary proceeding is pending against an employee. After due analysis, this court held that it is only when a charge memo is issued to the employee that it can said a departmental disciplinary proceeding is initiated against the employee. This issue was again considered by this court in Rajinder Lal Kapoor Supra. Respondent in that case was an officer of the UCO Bank. Following a disciplinary proceeding, he was dismissed from service. However, the High Court in writ jurisdiction converted the punishment of removal from service into one of compulsory retirement with effect from the date of superannuation. UCO Bank came up in appeal following leave granted before this court. On examining this court while opining that the High Court may not have been correct in converting the penalty of removal from service to compulsory retirement, however, came to the conclusion that initiation of departmental proceeding itself was wholly illegal and without jurisdiction. The charge sheet was issued on 13th November 1998, whereas the respondent had attained the age of superannuation on or before 1st November 1996. Referring to the relevant provision, that is Regulation 23 3rd of the UCO Bank Officer Employees Service Regulations 1979, which created a legal fiction of continuance in service of the concerned officer post superannuation if disciplinary proceeding had been initiated prior to superannuation, such continuance of service being only for the purpose of conclusion of the disciplinary proceeding. This court held that such a provision could be invoked only when the disciplinary proceeding had clearly been initiated prior to the respondents ceasing to be in service. Stop.